You want to pass your home to your children, but how do you do that without triggering tax issues, getting caught in probate, or giving up too much control? There are several ways to transfer your home, but some strategies carry major risks and others offer far more protection. In this video, I'll walk you through the most legally effective and financially sound ways to leave your house to your children in North Carolina and in South Carolina. My name is JP Rankin. I'm a licensed estate planning attorney in North Carolina, South Carolina, and in California. I've helped hundreds of families avoid probate, create generational wealth, and ensure their legacy lives on for generations. One of the most common estate planning questions I get is, what's the best way to give my house to my kids? Let's break it down clearly. What works, what to avoid, and how to do it the right way. Let me start with the risky option that a lot of people try, adding their children to the deed. Many people think that simply adding a child to their home's deed will avoid probate. And technically, it might, but this strategy introduces serious problems. First, you lose full ownership. You can't refinance or sell the house without their signature. Even more important, if your child experiences a lawsuit, divorce, bankruptcy, your home could become exposed to their creditors. Think about that. Your house, the place you've lived for 30 years, probably raised those children in, could be at risk because your child got sued or went through a messy divorce. Here's the tax problem. You forfeit the step-up in basis in your share of the property. Let me explain what that means. When you die and your child inherits your house, the IRS resets the cost basis to the current market value. That's called step-up in basis. So you bought your house at $100,000 and it's worth $500,000 when you die. Your child inherits it at $500,000. If they sell it, they owe zero capital gains tax. But if you add your child to the deed while you're alive, they inherit your original cost basis of $100,000. Now, if they sell it for $500,000, they owe capital gains tax on $400,000 of appreciation. It's about $80,000 in federal taxes plus any relevant state taxes. In most situations, adding a child to the deed creates more problems than it solves. Now, let's talk about transfer on death deeds. In some states, transfer on death deeds, also known as TOD deeds, let you name a beneficiary who automatically inherits your house when you die. This avoids probate and preserves the step-up in basis. Sounds great, right? Here's the issue. These deeds are not currently permitted in either North Carolina or South Carolina. So if you live in the Carolinas, TOD deeds are not available to you. Even in the states that allow them, TOD deeds come with restrictions. They don't provide flexibility, asset protection, or advanced planning options. You can't control how or when your child receives the house. You can't protect it from their creditors, and you can't set conditions on the transfer. So even if TOD deeds were available here, they wouldn't be my first choice. So here's the best option: a revocable living trust. A revocable living trust is the most comprehensive and flexible way to pass your house to your children while staying in control during your lifetime. Here's how it works. You create a trust and transfer your home into the trust's name using what's known as a quitclaim deed. You act as the trustee and maintain full control while you're alive. You can still sell the house, refinance it, or live in it. Nothing changes for you. Upon your death, the successor trustee distributes the home based on your instructions without court involvement. No probate, no delays, no public record. Additionally, with a living trust, you're able to avoid probate entirely, retain eligibility for the step-up in basis when your successor trustee goes to sell your home after you pass away, and create distribution rules to ensure responsible distribution of your inheritance. You can even set up additional decedent's trust to protect at-risk beneficiaries from sticky situations like lawsuits, divorces, or even creditors. You can keep the home in trust for a set period, distribute rental income among beneficiaries, or prevent forced sales. Let me give you an example. I had a client own a beach house in South Carolina. She had 3 kids. 2 of them wanted to keep the house in the family. 1 wanted to sell it and take the cash. If she had just left the house to all 3 kids equally, they would have been stuck. The one who wanted to sell could force a partition sale, and the other 2 would lose the house. Instead, we set up a trust. We gave 2 kids that wanted to keep the house the option to buy out the 3rd kid for a fair market value. Everyone got what they wanted, no fighting, no lawsuits. That's the power of a trust. You can customize it to fit your family's situation. Now, what if you have a mortgage? Most people do. It's a question I get all the time. Transferring your home into a revocable living trust generally does not trigger the mortgage's due on sale clause. You keep your loan and payments continue as normal. Your lender may request notice and your title insurance company might update its records, but these are usually administrative steps, not barriers. There are a few types of mortgages that may require some additional steps, but that's another reason to work with a seasoned professional who knows how to handle all these situations. Your children can inherit the home, keep it, sell it, or refinance it, depending on your instructions in the trust. Because the home is in the trust, they can do all of that without going through probate. Here's the bottom line. Your home is more than an asset. For many families, it's a symbol of your life's work. Don't risk losing control or creating avoidable tax consequences by relying on a strategy you heard from a friend that's likely risky, misinformed, or even outdated. I've seen too many families lose tens of thousands of dollars in taxes because they added their kids to the deed. I've seen families torn apart because one sibling wanting to sell and the other ones didn't. I've seen homes get tied up in probate for over a year because there was no trust in place. And all of this is avoidable. At Rankin Law Firm, we help families implement smart, legally sound estate plans that protect real estate and pass it on accordingly to your exact wishes. We don't just draft documents, we fund your trust, retitle your property, and make sure everything is set up correctly so your plan actually works when your family needs it. Schedule a consultation with us to see how a revocable trust can protect your home and your legacy. Links in the description. And subscribe for more estate planning insights that work. I'm JP Rankin. Thanks for watching.